Hi all, welcome to the Professional Visa and Education Services News Update. My name is Nish. I'm a lawyer in Australia and also Director of Professional Visa and Education Services. Today I'm going to talk about a growing request that the Department of Home Affairs are making in relation to your visa application, especially for permanent residency. Now, as you have experienced or you have seen the news in our social media page, and also, the people working in the similar industries are posting out lots of visas being granted, lots of pending visas being granted, especially 189, 190, and 491. However, there have been quite significant amount of further documents request by the Department of Home Affairs for the permanent residency application, especially in relation to the adversarial information on the visa application and also some natural justices. So I'm going to take you through what natural justice means in Australia, which is Section 57 of the Immigration Act, and also what is the further documents request, Section 56 of the Immigration Act. Now, in terms of further documents request, if the Department of Home Affairs case officer is not satisfied with the amount of document or the evidence or requirement that you have actually produced at the time of visa lodgement, or certain things is expired, for example, your Australian Federal Police check or your medical checkup with BUPA, or if they're not convinced with certain evidence or requirement, usually there will be a request for further information, which is backed up by Section 56 of Migration Act, which means that the minister should consider all the relevant evidence that is relevant to the application. Even that means if the evidence is provided after the visa application is lodged, the minister's delegate, which is the case officer, needs to acknowledge and consider those kind of evidence for the visa application. Now, the topic is mainly on the natural justice, because this is the more severe one, because the natural justice is the heart of the administrative law in Australia, which means it is also known as procedural fairness. So if the case officer has ascertained there has been some adversarial information which contradicts whatever the claims that you made on your visa application, then this is the last opportunity, this is the last lifeline that the Department of Home Affairs would like to provide that to the applicant, which is potentially going to get the negative outcome of that visa application, which is potentially getting refusal. Then the natural justice is then given to the applicant, which means either the applicant has to rebut the claim that was made or whatever the allegations been made on that natural justice, which means, for example, if you have claimed the employment points on your general skill migration visa and then made several attempts to contact your employer to validate your employment verification, and next thing is they've been receiving some adversarial or negative reply from the employer, or the validation process is kind of failed, then your opportunity is to then go and say, whatever the allegations the Department of Home Affairs are making in regards to your employer or employment in this particular example, then your opportunity is to go back and comment on the area that Department of Home Affairs are raising as the matter of concern. Now, usually, it also attracts, public interest criteria, PIC 4020, which means supplying immigration or providing immigration with misleading and bogus documents, which not only leads to a visa refusal, but also bars you from Australia for another 3 years. Now, it is very important, and this video is mainly for people, especially if you have received any adverse information, requests to comment or natural justice in regards to any adversarial claims or findings that the Department of Home Affairs has made in relation to your visa application. Do not take it lightly, because natural justice, again, is a procedure of fairness. It's a chance that is provided to a visa applicant to comment on the allegations or comment on the findings that the Department of Home Affairs has made. And there are ways. Sometimes we have seen the applicant rush to reply to the comment by the Department of Home Affairs quite quickly, which means there are certain times Department of Home Affairs would not expose all their findings on the comment. They will just talk about the area of concerns, and then sometimes, the applicant dig their own grave or by explaining things that, that is not true. And next thing is it leads to a visa refusal. So these things needs to be handled properly, which is effectively means we can request for the evidence that Department of Home Affairs is relying on making that allegation as well. We do have some legal standing in terms of requesting Department of Home Affairs on the facts they're relying on. So when you go and rebut, when you go and actually challenge those facts, then you wanted to make sure that you have a substantial amount of evidence to back up your argument, which will then lead to a visa approval. Now, in most of the cases, if it's a public interest criteria been imposed, the only way to get out of the public interest criteria is to, again, prove the Department of Home Affairs facts are not correct, or demonstrate compelling compassionate situation. A compelling compassionate situation has its range of example in the procedure manual, but again, there is no set definition of compelling compassionate situation in immigration law. Compelling compassionate situation is something that is beyond applicant's control. So look, the highlight of this video today is, if you have received a further documents request, if you're just asking for certain documents that is missing in the visa application, it's not a big deal. You can provide those information. And sometimes you just got to be careful, because sometimes it may seem like a further documents request in section 56, but it may be also the chance for you to provide a comment on the adversarial information the Department of Home Affairs has received. But the main area of the topic today is the natural justice or adversarial information that the immigration has found, and then you got a comment. It's a very critical piece of request that Department of Home Affairs are making. You cannot take it lightly, and again, you need to seek a professional advice before you comment or before you start replying to the natural justice section 57 of your visa application. Again, we are here to help you with any of the difficult or complex migration cases. Please feel free to come and see us. We are based in Sydney. We are also in Hobart. We are also in Canberra and Nepal, and also will be available in Melbourne very soon. But again, thanks for watching this important topic, because again, why is it relevant at this point in time? Because there are lots of visa applications are getting approved, but at the same time, there are lots of application where the Department of Home Affairs are putting a natural justice and requesting more information, or they have received some adversarial information on the visa application, and we have received quite a number of people approaching us because they have received some adversarial comments on the visa application, and they need to reply back to the immigration. Again, if it means health criteria for your child, health criteria for any of the applicant, if it's a character evidence, do not take it lightly. These are all serious matters, and this needs to be done professionally. So again, come and see us if you need any of the assistance around this area. More than happy to assist you. Thanks for watching, and I'll be back again with more update in the future soon. Thank you. Bye-bye.